Welcome to today's webinar brought to you by OraSure Technologies and Bravo Wellness. OraSure Technologies is a global leader in oral fluid substance abuse testing products. Their unique assays provide accurate and easy-to-administer testing methods to help determine the presence or absence of drugs or alcohol in a person's system. Oral fluid-based testing products provide a simplified collection process, faster results, cost savings with minimal risk of tampering, and dramatically reduced risk of adulteration. The Intercept Oral Fluid Drug Test is an FDA-cleared, laboratory-based oral fluid drug testing system that enables accurate testing for drugs of abuse, including marijuana, cocaine, PCP, amphetamines, and opiates. It was ranked as the #1 recognized brand name in oral fluid testing in 2014's National Drug Testing Industry Survey. With a fast and easy-to-administer collection process, Intercept is ideal for workplace, criminal justice, drug treatment centers, and clinical setting screening programs, among others. Today's presentation is entitled Workplace Cotinine Testing is Legal, Affordable, and Becoming Popular, and will be presented by Bill Current and David McLellan. Bill Current is the president and founding partner of the Current Consulting Group and the publisher of the online Ultimate Guide to State Drug Testing Laws at statedrugtestinglaws.com. He is the author of 10 books on substance abuse-related issues, including the popular title, Why Drug Testing? CCG is a leading provider of drug testing policy writing services, working with companies to help them optimize their drug testing ROI. Bill is the former executive director of the American Council for Drug Education and the vice president of consultant for Employee Information Services. David McLellan is a leader with over 30 years experience in the employee benefits industry and is known for his passion for wellness. He frequently presents to regional and national audiences, including human resource professionals, occupational health professionals, and insurance industry associations. His blend of compliance expertise with real-world best practices help give practical application to his audience. David joined Bravo Wellness in January 2009 as a regional sales director and became vice president business development in December 2011. Bravo offers health contingent wellness program compliance expertise, technology, support, and resource to employers and business partners. Employers receive best practices from Bravo's deep expertise in the industry, while employees are rewarded for actually achieving positive results and health improvement. It will now be our pleasure to hear from Bill Current and David McLellan.
Well, thank you very much, Jessica, and welcome to everybody who is on today's webinar. I'm especially excited to be presenting with David McLellan today. He has a wealth of expertise in this subject and in all things related to wellness, and so I'm looking forward to his part of the presentation. If you've ever been on one of my webinars before where I've been the presenter, usually I'll go about 30 minutes in, but I'm going to go a little bit shorter on the front end today and bring David in sooner. We're going to follow this outline basically, and he's going to come in right around the third bullet on the screen in front of you right now. He's got a great depth of information on the Affordable Care Act in all kinds of different areas of the ACA, including wellness programs and cotinine testing. So I think you'll find that really, really interesting, and we're going to put that in the middle. We're going to do a little back and forth as well. I've got some questions that I want to ask David specifically about cotinine testing programs, and we've talked about that a little bit in advance, so I'm looking forward to that. I'm going to kind of set the stage today with some statistical background on the entire issue of smoking and various effects of smoking, cessation programs, etc. You may recognize some of the information that's on the screen today from the advertisements and promotionals that we sent out for today's webinar. This is a very popular topic, especially right now, because of what's in the Affordable Care Act and the emphasis in the workplace for wellness programs to reduce healthcare costs and things of that nature. Cigarette smoking, we know, is bad for a person's health. It's related to all kinds of illnesses, which I'm gonna share some statistics with you in a minute. I don't know if you knew, though, I've never been a smoker my whole life, so it's hard for me to relate to this part of it. But the average smoker smokes up to 13 cigarettes a day. That's about 4 to 6 packs a week, and the average cost of a pack of cigarettes comes out to about $1,500 a year just using the average. Now, in New York City, and some places in the country, like in New York City, the cost of a pack of cigarettes can be as high as $13, which means that if you're a New York City smoker, then you're probably spending almost, a little over twice as much as somebody in other parts of the country. That's a considerable expense when you think about it, right? Think about what your cable bill is. Think about what your water and your sewage bill are and things like that and all the things you have to pay for. But in addition to that, you're spending $3,300 if you're a New York City smoker on cigarettes. Now, the overall cost in the U.S. is in the billions of dollars, almost $200 billion. About 97, it's almost half and half here. 97 billion attributed to lost productivity, and 96 billion contributed to healthcare costs. So employers have a real keen, invested interest in being aware of these statistics, knowing what's going on with the Affordable Care Act, with cotinine testing, with wellness programs, with premium differentials and other incentives to have smoking cessation programs, et cetera. And so we're going to get into all of that during today's webinar. Now, there are some statistics that you may not be aware of. You probably have the general idea, but it's good to understand these things because all of this factors back into costs that employers sometimes are responsible for through the healthcare benefits and whatnot that you provide to your employees and other factors. And some of this is very fascinating, okay? Now, we know that cigarettes are bad. We know that there's lots of different chemicals in a typical cigarette or in cigarette smoke that contributes to things like cancer, emphysema, chronic bronchitis, and deaths that are the result of these illnesses. Among adults who ever smoked at all, the vast majority of them started smoking at age 18 or younger, and 86% at 21 or younger. In other words, the earlier you start smoking, the more likely you're going to become addicted to smoking. Among current smokers, chronic lung disease accounts for 73% of smoking-related conditions, and even individuals who quit smoking, it's 50% of smoking-related conditions. Chronic lung disease, accounts for 50% of smoking-related conditions. It harms every organ in the body, and it's the main cause of lung cancer and chronic obstructive pulmonary disease, chronic bronchitis, emphysema, coronary heart disease, stroke, and other types of cancers and illnesses and diseases. I mean, there's nothing positive from cigarette smoking. Now, this is kind of interesting as it relates to the workplace. So a smoker costs a private employer in the U.S. an extra $5,800 a year compared to the non-smoking employee. Okay, and this comes from a variety of different sources. At Ohio State University, researchers estimated that the largest smoking-related cost was $3,000 annually from employees who smoke taking smoking breaks. Isn't that interesting? Compared to a non-smoker, a smoker on your payroll will take up to 5 breaks a day compared to just 3 for the non-smoking coworker. And the majority of that $5,800, $3,077, is from lost productivity of individuals taking smoking breaks during the day. The second largest cost factor, a little over $2,000, was related to excess health care expenses, and that's important, obviously. Now, the remaining costs came from increased absenteeism and other things related to lost productivity. It's kind of interesting. We often think about the cost of smoking in the workplace having a disproportionate impact on healthcare costs, and it is significant there, over $2,000. But the majority of the cost comes from lost productivity. Smokers on your payroll who are taking extra breaks during the day to smoke and who are absent from work and perhaps sometimes even tardy to work as well. Now, smoking cessation programs, they have a direct impact on the things that we've been talking about. You probably know nicotine. We're talking about cotinine testing. I'm going to explain why in a second, but nicotine is the ingredient in cigarettes that causes addiction. Okay, smokers become physically addicted, but they also become psychologically addicted because they associate smoking with various social activities where they smoke. And so they go to a certain place or they do certain activities. They smoke during those activities, therefore they become psychologically sort of addicted to smoking while they're doing those things. Back in 2009, nearly 50 million there were nearly 50 million former adult smokers. Of the nearly 47 million who were current smokers at that time, 46.7% stopped smoking at least one day in the preceding year because they were trying to stop smoking. Okay, sometimes you miss a day of smoking, right? But these were nearly half of all smokers tried to stop smoking, and they were successful at least one day in the last year. But smoking often requires multiple attempts. Counseling and medication alone help to increase the chance of a successful quit attempt, but sometimes it takes more than that. There's medications that have been approved by the FDA to aid in quitting smoking, things like nicotine patches, gum lozenges, nasal sprays, inhalers, etc. There are also, sort of external support sources. There's telephone and texting counseling. There's quit smoking support groups, things of that nature. This is just one that I found. There's others out there. This is a texting support program called KickButt. This one is KickButts 2.0, but it delivers messages via text to the individual who's trying to stop smoking, and there's various levels of success with this. The individual can program in keywords so that it will trigger messages to come when you need them. It's just one of the various ways to do this. There are a variety of different types of cessation programs. Maybe some of the people on today's call have participated in a cessation program. I know many years ago, both my parents were regular smokers. My mother actually went through a cessation program at her work that was sponsored free of charge back in the day where she worked, and she was able to successfully quit smoking, and that was probably about 30 years ago now. And bless her heart, she's 84, so I'm sure it contributed to extending her life. My father, unfortunately, never stopped smoking and died at the age of 61 of lung cancer, which was most likely attributed to having been a heavy smoker throughout his adult life. Cessation programs are a good thing to have. Not every company provides it, but where it's available, it can reduce the risk of things like chronic obstructive pulmonary disease, and it can also reduce the spread or the decline of lung function. It's always a good time to stop smoking. No matter how long you've been smoking, it's going to be a positive thing to stop smoking. Now, one of the questions I often get asked, and we're heading towards David's part of this, is it legal to test people for nicotine or for cotinine? And there are laws that you have to take into effect. Now, there's only one state, South Carolina, that actually prohibits workplace testing for either cotinine or nicotine. Now, of course, South Carolina is a place where there's a lot of tobacco farming, but it's in the culture there, let's say. I remember years ago, this was a long time ago, 20, 25 years ago, checking into a hotel in Kentucky and asking for a non-smoking room, and at that time, they looked at me kind of funny, like I was from Mars, because there were no non-smoking rooms in that hotel in Kentucky at that time. Nowadays, of course, you can find them virtually in every state. But besides the South Carolina law, all the other states allow testing for cotinine or nicotine. But there are other laws to take into account. There are smoker rights laws, there's privacy laws, and there's something called lawful activities laws. I'm going to spend a few minutes on that here in a second. You also have to take into account the Americans with Disabilities Act. But the big question, if you're an employer, is what do you do when someone tests positive, right? So South Carolina, you can't test individuals for nicotine. Other states you can, but what do you do when they test positive? Sometimes that's when lawful activities laws come into effect. And I'm going to show you 3 examples here in a second, but let me just detour from this just slightly to bring you up to date on a legal development that's going on in the state of Colorado right now, and it has to do with marijuana. Now, Colorado's become infamous in the United States, right? Because it was the first state, along with the state of Washington, back in 2012, where voters legalized marijuana for recreational use, not for medical use like you see in so many states now, but generally for recreational use, that's the term they use, it's legal in Colorado. Well, some years ago, there was an employee for Dish Network who tested positive for marijuana before it was legal for recreational use, when it was only legal for medicinal use. And that individual tested positive. He was a registered medical marijuana user at the time, but Dish Network terminated his employment. He has sued, and he has sued, and he's lost his suits, but now it's gone to the Supreme Court, and the argument now rests on whether the state's lawful activities law applies to marijuana, because now, of course, marijuana is legal in the state of Colorado. That will have a far-reaching impact not only on marijuana laws around the country, but possibly as well on nicotine and cotinine testing. Now, let's go on to a couple of examples. That's just something to be aware of for those of you who are employers and you're in a state perhaps that has a legal marijuana law. We're watching Colorado carefully. Here's the language, or some of the language, I should say, from the Colorado Lawful Activities Law. Okay, and I'm going to read it. I'm going to paraphrase a little bit here in a second, but let me read just at the beginning. It shall be a discriminatory or unfair employment practice. You see that terminology in virtually every lawful activities law. Unfair employment activity for an employer to terminate the employment of any employee due to the employee's engaging in any lawful activity off the premises of the employer during non-working hours unless such a restriction, A, relates to a bona fide occupational requirement or is reasonably and rationally related to the employment activities and responsibilities of a particular employee or particular group of employees, etc., and then B, is necessary to avoid a conflict of interest with any responsibilities to the employer, etc. So in Colorado, it's unlawful to terminate someone solely based on that individual's engaging in a lawful activity off company premises and during non-working hours. So that you can see how that could apply to a smoker who doesn't smoke while they're at work, doesn't smoke on company premises, but maybe they smoke at night when they get home, or they smoke in the morning before they leave for work. That could possibly come into play. Again, we're watching that court case in Colorado very closely. It's before the state Supreme Court right now. In Illinois, a little bit different slant. It shall be unlawful for an employer to refuse to hire or to discharge any individual or otherwise disadvantage any individual with respect to compensation, terms, conditions, or privileges of employment because the individual uses lawful products off the premises of the employer during non-working hours. There's the consistency in those last few words there, but this also relates to pre-employment conditions or situations as well. And then Mississippi, again, just a slightly different take here. It shall be unlawful for any public or private employer to require as a condition of employment that any employee or applicant for employment abstain from smoking or using tobacco products during non-working hours. See the little twist there, just a little bit different than Illinois, and Illinois a little bit different than Colorado and Mississippi. But if you're in a state that has a Lawful Activities Act law, which almost every state does, and you want to do cotinine testing of your employees either as a pre-employment screen or as part of a wellness program or as a condition of employment, you need to make sure you check these laws. It doesn't mean by any means that you can't test for cotinine or nicotine, but it may affect what the consequences can be. Okay? So that there's a whole lot more. I mean, we could do an entire webinar just on the legal implications. The bottom line is that with the exception of South Carolina, nicotine testing or cotinine testing of employees is legal in every other state. There may be conditions that affect the consequences of testing positive, but it's legal to test your employees to see if they're smoking as a way to keep them honest or as a way to screen out job applicants, etc. There are other things that come into play. Now, David and I have been on the phone a number of times over the last several weeks coordinating and preparing for today's webinar. He's really an expert on the Affordable Care Act. Some people refer to it as Obamacare, but it's the Affordable Care Act, the ACA. He's going to talk about that, and he's going to get into some other issues that are sort of related to that as a sort of a lead back into specifics on cotinine testing when I'll come back into the webinar, and then we'll also talk about oral fluid testing in particular. So I'm going to switch over to David's slides now, and I'm going to pass the ball to David, and then David, you've got the virtual microphone.
Very good, Bill. Thank you so much. It's been a pleasure to sit and hear you talk about the legal ramifications of cotinine testing. And as you know, for our audience's purposes, our frame of reference at Bravo Wellness on cotinine testing really comes from our unique space in the wellness industry. And what I'm going to talk about today is really related to health contingent wellness incentive programs and how employers can test for cotinine relative to their wellness incentive program. Because of our compliance expertise, we really were one of the first companies that were consulting and administering outcomes-based wellness incentive programs. And those programs actually offer a safe harbor from the non-discrimination regulations that we'll talk about here in just a moment. And with those programs, then, our clients are routinely testing for cotinine because they're rewarding significant dollars for being tobacco and nicotine free. And that testing then provides a way to verify whether they are or not tobacco free. So what I want to cover today relates to those wellness regulations under the Affordable Care Act. And as Bill said, sometimes that's referred to the ACA. We'll use that abbreviation here in this presentation. But very specifically, we'll talk about what their wellness regulations say, probably more importantly, what they don't say, and how that relates to an employer's plan, and how they can use those regulations in their wellness incentive program. Now, there are some advantages and some cautions that we'll talk about in a health contingent approach. And when an employer uses a tobacco, non-tobacco differential in their premium contributions, there are certain things that an employer needs to follow, some compliance aspects that we'll talk as well about. We'll also talk about really nicotine screenings or cotinine screenings in this tobacco surcharge world, because this is becoming very popular with employers because of the costs that Bill referenced earlier. And if the costs attributable specifically to smoking are not enough, employers can and are routinely creating premium differentials. Sometimes they're surcharges, sometimes they are discounts related to being tobacco-free or being a tobacco user, depending on how the employer decides to set up their premium contributions. So we'll talk a little bit about those aspects of a wellness incentive program and really how the Affordable Care Act relates to some of those programs. While I don't want to give a detailed history or lesson here on the regulations, it is important, though, to know that prior to the Affordable Care Act, there were regulations that allowed employers to implement a tobacco surcharge, as well as other premium differentials based on health factors. Those regulations were enacted in 2006. They became final in 2007. And then the Department of Labor really essentially created a compliance checklist and further clarified those regulations in February of 2008. So when the Affordable Care Act was enacted in 2010, that law essentially imported all of the regulations in HIPAA into the new law. They did expand a few things that we'll talk about here in a couple of moments as well, and changed a little bit of those regulations that were a part of HIPAA. But essentially, when an employer creates a program that differs a premium contribution or a health savings account contribution because of a health factor, that is permitted as a safe harbor under the Affordable Care Act wellness regulations if it is done within the guidelines of the wellness program rules, which really relate to the health plan. So the health plan and altering the contributions of the health plan is really the safe harbor for these types of programs. Sometimes we get asked if an employer wants to be very generous and reward employees for losing weight in their wellness program, and if those employees are not on the health plan, there can be some situations where that can be very problematic. So from a compliance perspective, but all of the wellness regulations that are in place now are subject to HIPAA, the Department of Labor and IRS and state regulations. And because this relates to your health plan, these types of programs are subject to a Department of Labor audit for up to 7 years. So it's very important that when you put a program like this in, even if it is just a tobacco surcharge or discount, that you keep very good records and maintain full documentation. And essentially, especially when it comes to HIPAA privacy, you need to make sure that those privacy components are in place and then include any audit trails for who accessed their protected health information and keeping a log for that access as well is very important. One thing that I'll touch on today that is sometimes misunderstood or not understood by many employers when they begin down a path of creating a wellness program. And initially, a lot of employers will implement the tobacco surcharge or the non-tobacco discount as the way of really introducing a wellness program because of all of the aspects that Bill mentioned earlier and the costs associated with smoking. They'll introduce a tobacco surcharge, as I said, but when they do that, under the Affordable Care Act wellness rules, that really throws them into what is considered a health contingent classification and really brings into play some requirements for the plan to be able to be considered compliant. So as you'll see here on this particular visual, there are two different classifications of wellness incentives, one being a participation-based side and the other being a health contingent side. The participation-based side are things that are not really related to what we're talking about today in terms of testing for cotinine, but they're things that have been around for a number of years in wellness programs, completing a health risk assessment and getting a reward card, getting a gym membership, and perhaps even having an incentive to go through a screening. Those are all considered participation-based programs. But when an employee is rewarded based on a health factor, such as having a cholesterol at a certain level or being tobacco-free, then that's when the program moves over to a health contingent program. And with that program then comes the necessity for having alternative ways to qualify. Sometimes these alternative ways to qualify for the reward or to avoid the surcharge, sometimes they're called alternative standards. Sometimes people will call them reasonable alternatives. But essentially, if you have a tobacco surcharge or a tobacco differential, let's say, then an alternative needs to be provided for that employee if they are in the program and they need to be given an alternative way to qualify, even if they do not have a medical issue preventing them from achieving the goal. So in the case of tobacco, the only alternative, the only reasonable alternative for achieving the reward is a tobacco cessation program. And that tobacco cessation program can be as easy or as difficult as an employer wants to make it. In some, it can be unreasonably difficult, obviously, but many employers who are putting in a surcharge for tobacco want to be able to incent and reward people for actually improving their health, because it relates back to their health plan, and they want to be able to have employees healthy so that it impacts their claims. So with that in mind, then the tobacco cessation program could have some teeth to it. And what I mean by that is that it could be a plan that is requiring some effort by the participant. So we'll talk about the tobacco cessation program here in just a moment. But the one thing that is interesting to note is that if you're using a tobacco surcharge, the amount that you can use to create that differential can be as much as 50% of the COBRA rate, or 50% of your fully insured rate. And we'll talk about that here in just a moment as well. So when we talk about alternative standards, I'm going to kind of switch here for just a moment to traditional wellness programs and other aspects, not just tobacco, because if I have a wellness program that is in place that's rewarding an employee for, let's say, having their cholesterol at or below a certain level, there are some plans that will say that you have to have a participation-based alternative way to qualify and earn all of the outcomes-based incentives, and there needs to be an alternative to the alternative in the case of having a medical issue. But really what the regulations actually say, and this is really important to note, is that the plan must provide an alternative standard for every outcomes-based incentive. It could be a participation-based program alternative. In other words, if I can't meet the cholesterol goal, I could go through an online program to help teach me how to naturally lower my cholesterol. Or it could be in itself another outcomes-based goal that could be more reasonable for me. So the employer could say, you need to have your LDL cholesterol at or below 130, or lower that cholesterol by 5%. And that could then become the reasonable alternative. So sometimes there's a perception out there that these reasonable alternatives have to be just a participation-based program, and that's really not necessarily the case. You can use a participation-based program if you want to, but essentially what that does then is it dilutes the results-based program. So just as a practical application, one of the ways in which we administer programs for our clients is that we will create two types of appeals. The type 1 of appeal is where an employee basically is attesting or is appealing the fact that their results may be incorrect. So they think that their results are incorrect. For example, there needs to be a way to be able to correct an honest mistake. So if the screener writes down and inverts a blood pressure, instead of 180/20, it really should be 120/80. So that type 1 appeal helps an employee to be able to correct their biometrics in an outcomes-based program. Now, the other type of an appeal is what we call it just a type 2 appeal, which is where I have a medical issue that's preventing me from hitting my reward. And so in that particular case, we're going to ask the physician to attest to the condition as well as offer an alternative way to qualify if the reasonable alternative for the plan is not appropriate for that particular individual. At the end of the day, one of the key things to the Affordable Care Act is that the personal physician really is the final judge of what's appropriate for their patient. So if an employee has a family history of cholesterol issues and the physician is working with that individual, the physician can actually provide a waiver, and really there cannot be any overriding of that particular issue from the physician. So I talked about a tobacco cessation program, and one that we've partnered with is QuitLogix. One of the reasons why we partnered with this particular organization is, number one, they've got a great track record. They've had over the years a 40% quit rate for their participants. They've had almost 1 million participants that they've coached. But the real reason why we partnered with QuitLogix is because they were able to create a program that had a reasonable chance of an employee quitting. And that's the ultimate goal for at least of the clients that come to us wanting an outcomes-based or a health contingent type of a program. And this particular program requires an employee who does participate to go through 5 coaching sessions over a 10-week period in order to be considered completed the program. So there are some hurdles that an employee has to go through in order to get the reward and go through the reasonable alternative, but it is something that has a reasonable expectation that the employee would become tobacco-free at the end. One thing I didn't mention in an outcomes-based program, just because an employee goes through the tobacco cessation program and completes it does not necessarily mean that they have to be tobacco-free at the end. And that's one of the reasons why we created a program that had a few hoops to jump through and some hurdles to jump over, so that that employee who chooses to participate in this reasonable alternative for tobacco cessation really has, an incentive and some skin in the game and a reasonable chance at quitting. We didn't want a program where someone could just game the system. So let me talk now just briefly about how the differential works. So in the Affordable Care Act wellness regulations, it talks about the differential that is available to employers. That differential, if an employer is using only tobacco as the differential, the employer can use 50% of the cost of coverage. So in other words, 50% of the COBRA rate or 50% of the fully insured rate for the employee. If, however, they want to add other wellness categories, other biometrics, such as blood pressure, cholesterol, glucose, and body mass index, those elements have a maximum differential of 30%, and then they can add a 20% differential specifically just for tobacco. Now, I will tell you in practical terms, I don't think we have very many employers who are using the full 50% of the premium. I know that we do have many employers who are using a full 30% of the premium as a differential, but 50% of a COBRA rate is a pretty big number, and so that can be a very big differential and a wide swing. One thing also to note too, and this is a separate issue, different from the wellness rules and the differential that's allowed. But one thing to note is that when calculating affordability for the Affordable Care Act, sometimes it's referred to as the 9.5% rule. The only component of a wellness program incentive that can be included is tobacco. So in other words, what you want to do is take a look at what your non-tobacco users would pay and use that for your 9.5% affordability. So that's a totally separate discussion and a totally separate calculation from the differential that's allowed under the Affordable Care Act wellness regulations. Now, when it comes to practical application and administration of these types of programs, many times there are elements of the regulations that are silent, and some employers were taking the approach that they could allow an employee to complete the reasonable alternative any point during the plan year, and they would just have to make the reward retroactive if that occurred. However, in January of this year, there was an FAQ that really confirmed what we had, the approach that we had taken, and that is that there can be reasonable time frames administratively to be put into place so that reasonable alternative can be enrolled in, completed, and be completed in a timely fashion, so that a timeline can be developed and a workflow put together so that the retroactive premium contributions don't necessarily have to drag on throughout the entire year. One of the things from a practical administration perspective that we've put into place for our clients is that we try to create a timeline whereby all of those reasonable alternatives are completed by the time their plan year starts and the premium contribution begins at the beginning of their plan year. That way, the payroll people are not having to jump back and forth and add retroactive adjustments. So just a couple of things here as we get to towards the end of my component of this particular presentation. A couple of things just to recognize in a health contingent program, specifically when you're talking about testing for cotinine. If you're going to put together a program that is outcomes-based and you're going to use some of the other biometrics that we talked about, other than tobacco or nicotine, if you use an alternative way to qualify that is just participation-based, essentially that just creates kind of a very complicated way to achieve a participation-based reward. So there's some easier ways to do that, and we could definitely help put something like that together that's more simple. But it is a conservative way and a conservative approach to compliance, but it's pretty costly. One of the things that many employers like to do is to try to create a premium contribution strategy that would actually put a cost-neutral approach to their wellness program. And using the health contingent rules, they're able to do that in many cases, and we can help create a program and a premium contribution that has the best chance of them being able to achieve that cost-neutral approach. So really, just as a recap, all participants need to be given an alternative way to qualify when an employer is using a health contingent type of a program. Not only that, but the programs and resources that an employer needs to be provided, they should be provided to encourage and help people succeed. And just like the tobacco cessation program needs to be in place, the program completion really shouldn't be necessarily the alternative goal, but health improvement should be the alternative goal. Sometimes that a modified, easier to achieve outcome can be used very effectively to help an employee improve their health, and also then be a compliance aspect of an outcomes-based program. A couple of just final cautions when it comes to an outcomes-based program, and this applies to not only a tobacco surcharge health contingent program or a full wellness incentive program that's health contingent. Employers need to anticipate resistance. There will be some resistance, there will be some backlash. However, one thing that we found that overcomes that is really clear and effective communications, and that's really the key to any program. And not only is it a compliance aspect, but it's also a best practice. Another thing you want to make sure of, too, is that you amend some of your plan documents, especially if, and I didn't talk about this, but if you use your categories, your wellness categories, to reward an employee with a better plan design. So sometimes employers will use a health contingent program to reward an employee with a lower deductible. There are some considerations in your health plan that you need to be aware of, and you need to amend your plan documents relative to the Fair Claim Standards and requirements for review rights. And really the other thing, too, that is important to know is that just because I've been talking about the Affordable Care Act regulations, there are other regulations that apply to outcome-based wellness incentive programs. Most recently, the EEOC has sued a couple of employers because of their wellness programs, not specifically necessarily for the tobacco surcharge, but really the voluntary nature of the program. So it's really important to take a look at all of the other regulations that may apply, EEOC, ADA, HIPAA, IRS, and state regulations. As Bill alluded to in some other states, there are other developing regulations that need to be taken into consideration as well. And I did talk about the impact of wellness incentives on the affordability calculation. If you're using a tobacco discount, a non-tobacco discount, that can be used for your affordability calculations under the Affordable Care Act regulations. So I think with that, Bill, I'm going to toss it back over to you, although I actually forgot this slide was in here about e-cigarettes. And one thing that we should talk about real quickly is making sure that e-cigarettes are within an employer's definition of tobacco and nicotine products. Because e-cigarettes do have nicotine in them, that is the component of that we test for. The cotinine is the byproduct of nicotine, and that will appear in your blood test or in the oral fluids test, in this case with OraSure's testing. So make sure that if you are going to use a tobacco surcharge, include the e-cigarettes in your policy so that employers or employees know that that's a component as well.
Perfect. Thank you, David. And
Thank you, Bill.
Well, David's passing the ball back to me. Let me just remind the audience of two things. One, if you have any questions at all, please submit them, of course. Any questions we can't get to during today's presentation, we'll take up afterwards and we'll email you a response. But also, you're going to get a complete copy or a link to a complete copy of not only today's webinar recording, but also to the slides I've been using, as well as to the slides that David just went through. So you're going to have access to all of the information that we talked about today in all of the different slides. So some of the slides I know that I went through at the beginning, which were very statistic numbers heavy, I didn't talk about all of it, but you're going to get it if you want it. So just rest assured that any information we talked about today on these slides is going to be available to you. Now, as David mentioned, nicotine is the psychoactive ingredient in cigarettes that causes addiction, and cotinine is the major metabolite of nicotine. That's why we're talking about cotinine testing in particular. It's only produced when nicotine is metabolized. So if cotinine is present in an individual system, as he said, in their blood or in an oral fluid sample if you're using the OraSure device, then that means that the individual's either been using tobacco products or they've been exposed to the tobacco smoke. It doesn't necessarily mean that the person, it doesn't say anything about their health necessarily or their ability to do certain tasks or job-related functions. But it does, because cotinine is only present when nicotine is present and it's the metabolite of nicotine, then it does mean that there's been at least exposure to tobacco smoke or the individual's been using tobacco products. Okay, now whatever consequences an employer has are up to the company policy, and they may be affected by state laws and whatnot. But that's why we're talking about cotinine testing, and we're using that term cotinine. Okay, now you may include it as part of a smoking cessation program, as part of an employment screening program, for evaluations of individuals for health or insurance programs. I've got to go through a health evaluation tomorrow for a new life insurance policy that I'm signing up for. It also could be part of a health or wellness program like David talked about. It depends on the various ways that are the various elements of your program within your company. Now, it's important to point out, David mentioned serum. Cotinine tests can be based on blood samples or urine, saliva, or hair. The problem that you may run into from a practical standpoint as an employer when it comes to blood, urine, and hair, that because of the complexity of the test, it requires the services of a professional technician, a professional biometric service provider at an off-site laboratory. The advantage with saliva-based tests is that it's easy to administer and it doesn't require the services of a professional technician. You can actually have employees who are trained to conduct the test, to collect the saliva, because it's so easy to do. And so in the case of OraSure, the sponsor for today's webinar, along with Bravo Wellness, is they manufacture a lab-based cotinine test with urine, serum, or oral fluids, and they also offer an instant result test device as well. I'm going to talk about both lab-based testing and instant testing for cotinine here in a second, but it's important to know there's some advantages to oral fluid testing, just like there are for the workplace. It doesn't mean it's better than the other systems. It depends on what your needs are, either as an employer or as a provider to employers when it comes to cotinine testing. One of them is the window of detection. So you've got, and I think I've got a slide coming up on this, so I may spill the beans here a little bit, but with regular nicotine testing, the window of detection is very short, but with cotinine, it's several days. And so the test can be administered within 4 to 7 days after an individual's used tobacco, and it's going to be detected in that oral fluid sample. Just like with drug testing with oral fluid, it's non-invasive. The collection process is always completely observed, so that eliminates the possibility of tampering with the specimen, et cetera. If you're using a rapid test device, which is also available, the result is available within minutes. If you're using a lab-based test, we're talking about, within 24 hours. Now, this is just a plug for a brochure that's available from OraSure, but if you want it, let us know. We'll get your contact information to OraSure. It's a frequently asked question guide to testing for tobacco use. It's good. I've seen it. I've read through it. I've probably contributed some content to it. But if you want it, let us know. We'll make sure OraSure sends that out to you. As I mentioned, cotinine is a first-stage metabolite of nicotine, and here's the part about the window of detection. With nicotine, it's only a couple of hours. With cotinine, though, we're talking about several days. That makes a pretty big difference if you're testing as part of a wellness program, and it's sort of trying to keep the individual honest with their commitment to be a non-smoker so they qualify for a premium differential. Now, with the OraSure oral specimen collection device, you're collecting the specimen on site. Like I talked about, it's easy to do, so you can train employees to do it, but the specimen is being sent to a laboratory. I want to be clear, this is a laboratory-based test. you're collecting the specimen on site at the workplace or wherever you're actually administering the collection, but the sample's being sent to a laboratory and you're receiving a lab-based result. The collection process is just a couple of minutes. Within a day, you're going to get the result back from the laboratory, okay? You're not talking about drawing blood or collecting urine, so you don't need those, the logistics that you would normally go through to draw blood or to collect urine in the privacy of a bathroom stall, etc. But, that's an option. And so we're not saying that one's better than the other, but depending on your circumstances, you may prefer one over the other. I'm not going to go into a lot of detail on this particular slide, but just to let you know as an audience that there is the rapid result cotinine test also available. You're talking about 10 to 15 minutes from start to finish in terms of being able to get a result back. And there's information on this slide, and I'm going to send you this slide. But you can see at the very bottom, the correlation to a lab test is 99% for specificity and 98% for sensitivity. So you're talking about very, very close correlation in terms of the results. And that leads me to this slide, which I find this one really fascinating because the way the numbers jump around. But I did a presentation on cotinine testing several months ago with an individual from Southwest Laboratories. And the perspective from the laboratory is interesting because they're getting samples in from lots of different companies. It could be as part of a wellness program. It could be part of an employee screening program. It could be part of a cessation program, et cetera. And so they're actually just looking at the totality of the samples that they're testing and then what percentage are actually positive. You can see it jumps around a little bit. Now, the 2014 numbers, this was early in the year, so they didn't have the volume there to say whether or not it's comparable. But in 2010, 1%. The next year, it jumped up to almost 14%. But what I understand from the presentation was that that particular number was so high because they brought on a company brought on a new program. And the point there is that once the cotinine testing is in place, then the deterrent impact is in place also. At the beginning, as a screening product, it may not be there, but once it's part of a wellness testing program, a cessation testing program, then that deterrent impact is there, which the smoker wants, incidentally. And so the testing is intended to help motivate and inspire them to stay smoking free. And so here again, take it for what it's worth. The positivity percentages here jump around quite a bit, as do the numbers at the top of the screen. But the fact of the matter is, even though somebody may say they're not smoking, they promise to not smoke, they're probably, in some cases, there's a percentage of them that don't smoke because they know they're going to be tested. They've agreed to it. They want that incentive in place. Now, between David and myself, I think there was a lot of good information, but we went a little bit farther in than we normally would, and we're out of time. We don't really have time for Q&A, but for all the questions that have been submitted, we will get to your questions. We will provide information to you. But let me just reiterate something. Jessica's going to come back on to give you instructions here, a little bit more information. But our slides are available. If you want them, we're going to send them to you, both mine and David's. Also, the recording of today's webinar presentation, we're going to provide a link so that you can go into YouTube and watch it. You can come on our website. You can go to the OraSure website and watch it, any variety of ways. And also, if you would like the FAQ document from OraSure on tobacco testing, then let us know. Send us a follow-up email, and we will either to the follow-up email we're going to send you, or I get them all the time. Right after this webinar is over, I'll get a dozen of them instantly. But if you want that, we'll provide that for you also. Once again, I want to thank our audience for coming on to today. I know this is an emerging topic. There's lots of questions from the accuracy standpoint of different technologies to the legality and the Affordable Care Act, which David did an excellent job of explaining, as well as the whole idea and concept of safe harbors for premium differentials and whatnot, which has a direct impact perhaps on a decision, a corporate decision, whether or not to do this type of testing. Again, thank you to David as well for his part of today's presentation. And thanks to OraSure for hosting today's webinar, and I'll turn it back over to Jessica for our conclusion.
Thank you, Bill, and thank you, David. On behalf of OraSure Technologies, we hope that you have found today's presentation informative and helpful. This presentation was recorded, and you will receive instructions informing you how to access the recording. Thank you for your attendance today. This concludes today's webinar.